All rise. The Court of Appeals, First Appellate District of Ohio, the Honorable Pierre Bergeron presiding. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have 3 arguments on the calendar today. I'm going to call each of the 3 cases. When you hear your case called, you can just stand, introduce yourself, and indicate your readiness to proceed. First case is Tintman versus Barbarette.
I'm Solomon Tintman.
Okay, thank you.
Christopher Trump for the above.
All right, thank you. Next case is In Re OGH.
Michelle Listagner for Appellate, ready to proceed.
Okay, thank you.
James Moskowitz for appellant, ready to proceed.
All right, thank you. And then the final case is Danziger and Delanio versus Morgan Verkamp.
Rob Sparks for the appellant, ready to proceed. Bruce Johnson for the appellate, ready to proceed.
Okay, thank you. All right, each case will have 15 minutes per side to be argued, and Mr. Tintman and Mr. Trollinger, you may proceed. Come forward. I'll keep your time, and when there's about 1 minute left, I'll hit the yellow light, and when it's, yes, please. And Mr. Tintman, you can reserve part of your time for rebuttal. Would you like to reserve any time for rebuttal?
Yes, 3 minutes.
3 minutes, perfect. You may proceed when you're ready.
If it may please the court. So today there are a couple of overarching matters that are, in my eyes, very simple. The first is jurisdiction and the lack thereof by the state of Tennessee in the attaining of it by the state of Ohio. Ohio State, Ohio Appellate, and United States Supreme Courts have all ruled that subject matter jurisdiction cannot be conferred where there is none, and it cannot be waived, and it can be raised on any time, even upon appeal, I should say. Home state jurisdiction is subject matter jurisdiction. Divorce jurisdiction is subject matter jurisdiction. There are undeniable facts on the record that regardless of the appellee's admission, the timing and location of the filing, and evidence that state Tennessee did not and does not have jurisdiction. Subject matter jurisdiction via home state, over the divorce, or through personal service.
Well, then wouldn't the procedure to be to challenge that in Tennessee?
That would be correct. There was a challenge in Tennessee. However, from my understanding of the law and the facts, that from the United States Supreme Court ruling that I gave in my brief, jurisdiction can be challenged at any venue. It's just my understanding of that. And when there is a lack of it, is a nullity to begin with. So I was going to kind of talk about that here in a second. The lack of personal jurisdiction, subject matter jurisdiction, isn't a voidable order, but it's a void from the beginning, ab initio. I think that's what you guys say, correct?
It is.
I'm not sure if I said
Good
that.
pronunciation.
Elliott versus Pearsall, United States Supreme Court, very old ruling, stated that if a court is without authority, its judgments and orders are regarded as nullities. They're not voidable, but simply void, and they they form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are in law as considered as trespassers. And then coming down to the state of Ohio ruling, I referenced in my brief State XREL ML versus O'Malley, I think year 2015. There was a case regarding child custody where I don't think I need to read the entire thing, but essentially what was stated was that Ohio was the home state, and because of the lack of personal service, the other states' orders were void, if that makes sense. Regardless if it was voided, a new case number doesn't create a new filing. It's when you talk about the UCCJEA provisions, it's talking about the first filing that starts the clock, if that makes sense, not a clock in a new state. So when the case was filed in the state of Tennessee, the home state was still Ohio per the home state provisions of the UCCJA. I think that's 3127.5A1, I believe, in Ohio, which provides that when a child is taken out of state and there's a 6 month period where you have to have jurisdiction. If a parent remains in the state, that is the home state. I believe that's correct, but let me continue. Ohio Appellate, Ohio State Supreme, and United States Supreme Courts have also ruled that any appeals that have a question of law, whether they're statutory or constitutional in nature, are reviewed de novo. Now, why is that important? De novo reviews, a de novo review of this case will reveal a few things. It would show when and how the filing was given, and it would show the lack of jurisdiction and the void nature of the orders. Again, not voidable, but just void. They shouldn't be, they're nullities.
And are you indicating that, what is the basis for saying the Tennessee court did not have personal jurisdiction over you?
Service. There was in the record, it was actually admitted, I think it's, I can't remember the name of the exhibit, but there is proof from the Secretary of State, Tennessee, that their service process was undelivered, and that was given to the trial court for review. A de novo review would show the deceptive nature of the stay, whether temporary at first, which, I mean, upon a de novo review, you would see that there's some contradiction between what the appellee says. So there's evidence that says, evidence that was admitted that says, okay, I miss you, from the appellee to the appellant. But then at the trial, the appellee stated that, what did she say? Sorry, losing my train of thought up here.
That's okay.
She stated that from the beginning, that was her initial intention to leave the state with the child and not tell the appellant on purpose. That was admitted on the record. And regardless if it was temporary or initially misleading, the child was removed, retained, and secreted against not just UCCJEA provisions, but Hague provisions as well, which I'll talk about here in a second. A de novo review would also show that the trial court was asked to review the case and the UCCJEA pursuant to the case law, pursuant to UCC 1-103, which doesn't abrogate the common law or anything, but rather supports it and makes uniform the law amongst various jurisdictions. And when you look at de novo review with the UCCJEA compared with the case law, you would see, and it would substantiate the nature of the void orders and the lack of jurisdiction. It would display, a de novo review would display their affidavits regarding the reference of evidence as to the appellee's action. There was an affidavit submitted April 1st, way before the trial was heard on the 24th of May, and then there was also one regarding UCCJEA May 17th of 2022. Sorry, I'm losing track of my years here. But anyways, continuing, it's a fact through the evidence on the record that via the home state provision, ORC 3127.5A1, that Ohio is the home state, like I said earlier, just from the fact that when there was a 6-month period that did not happen yet, there was a filing that did happen, and the appellant was still in the state of Ohio. The purpose of the UCCJEA is to prevent these types of things from happening, from children to being taken from one state to another. Before the UCCJEA, as you guys know, there was a UCCJA, which caused a whole bunch of mishaps and miscommunication and debates in terms of jurisdiction and who had this and who had that. But that was the main reason why home state jurisdiction was one of the primary things that was provided for in the UCCJEA, which was passed by, I think, every state besides Massachusetts. When you look at that purpose and you look at the convenient timing of the appellee, along with the nature, it's very evident on its face the purpose and the nature of what was done by the appellee. And there's binding authority, again, regarding that, that Ohio is the home state. That's State XRL, ML versus O'Malley. Along with jurisdiction, void orders, and Ohio being the home state, because the trial court judge herself even stated that Tennessee did not have home state jurisdiction. The unjustifiable conduct by the appellee not only permits Ohio, but it compels Ohio to return the child back to Ohio, since they are the court with home state jurisdiction to do so and are bound so by The Hague. Tennessee doesn't have any authority to determine whether or not it should decline or accept jurisdiction to begin with. It's a fact on the record that the appellee admitted to secretly removing the child without telling the appellant. It is a fact that through the record, the appellee hid the address from the appellant. It's a fact on the record that the appellee admitted to listening to her attorney's advice to keep the child away from the appellant. And it was stated by the trial court magistrate that attorney-client privilege is protected, but that is not the case when attorney-client privilege is used to create a crime or a fraud.
Let me ask you, Mr. Timpman, you keep referring to the record, and it's my understanding that no transcript was filed along with your objections to the magistrate's decision.
Mm-hmm.
Is that true or false?
That is correct.
So you're referring to the record that we don't have.
Say that again.
There's no transcript filed with your appeal.
What do you mean?
You keep referring to the record, and are you referring to a Tennessee record or an Ohio record? Or
Just like evidence and everything, yeah.
Okay. And my understanding was that there was no transcript filed for the judge to consider when you filed your objections.
Yeah, so I covered that in my reply to the appellee's brief. There wasn't a transcript, but there were affidavits on the record, and the binding authority from the state states that if there are affidavits on the record, that those can be used in lieu of a transcript. The transcript is for the facts, not necessarily the conclusions of law.
Okay, because you keep referring to the record and what appear to be facts.
Yeah.
Okay, that was my only question.
Okay, sorry. Article 3 of the Hague Convention on the Civil Aspects of International Child Abduction orders that the removal and retention of a child is considered wrongful, where essentially it's a breach in rights of custody of someone, and at the time of the removal, those rights were being exercised. In Article, I think, is 12, when the child has been removed from a person or someone that has been exercising those rights, the Hague demands that the state will return that child as well. And that is a mandatory authority just from the way that it's worded. It says they shall order the return of the child. Ohio Revised Code 312732 binds Ohio to follow that provision of the Hague and to enforce it. Apologies.
And Mr. Timpman, you're at your time if you'd like to reserve 3 minutes still.
I'd like to use 2 more minutes.
Go right ahead.
I know best interest of the child standard would probably be used, well, what's the best interest of the child, et cetera, et cetera. The best interest of the child standard does not apply to it in regards to initial jurisdiction determinations. That was actually in the case that the appellee had cited, Rosen versus Celebreze or Celebreze, I'm not sure if I'm saying that correctly, in paragraph 21. Regardless of the issues of jurisdiction, the appellee should receive no leeway to have home state jurisdiction due to their actions of removing, secreting, and retaining the child, just from the maxims of equity, because those who enter into equity must enter with clean hands. Equity will not allow a wrongdoer to profit by a wrong. Equity follows law, and obviously there's no principle of equity or statutory nature that can override the common law, especially the common law of subject matter jurisdiction. Finishing up, Magistrate Sanderson I know I'm not supposed to use names here. The trial court magistrate twisted the home state provision of the UCCJEA for the appellee, because 6 months is 6 months. The state of Ohio versus Warren in 2018 stated that normally statutes should be interpreted by their plain meaning, and if the language is clear and unambiguous, then you must apply the statute as written. Pursuant to 3127.44 in the state of Ohio, the appeal should have been on the expedited calendar. I understand because of the pandemic, and you guys probably have one of the hardest jobs, if not the hardest job in the entire country, It's no fault of you guys at all. But with that being said, in lieu of the untimely nature of this appeal, I would ask the court to make a ruling that is reflective of the void nature and the home state jurisdiction that is had by Ohio and the lack thereof by the state of Tennessee. Lastly, I'd ask a few questions for this court to ask themselves and for opposing counsel. What authority does any court have to ignore the lack of jurisdiction and to adopt an order without said jurisdiction? And under what authority does any court have to ignore binding authority from the Ohio State Supreme Court and the United States Supreme Court regarding orders made without jurisdiction and their void nature?
Okay, thank you very much. You'll have a minute left for rebuttal.
Correct.
Mr. Trollinger? Morning.
Thank you very much. Good morning. May it please the court. This case is ultimately very simple. It's a Tennessee action that was initiated in November. That action preceded any contest of that action should have occurred in the state of Tennessee. Ohio, speaking of jurisdiction, would not have jurisdiction to void or make void an order of another state. Under the UCCJEA 3127.20, it's very clear that when there's another action proceeding in another state, this court, the Ohio court, is to contact that court. There's indication in the record that in fact happened. Tennessee proceeded to act in conformance of its jurisdiction and its own determination, made final orders prior to this court Ohio courts making any orders, and then therefore concluded the matter in Tennessee. There is no transcript filed, so this court is left with the findings of fact as determined by the magistrate. Any factual discrepancies would be left to as the magistrate found them.
Counsel, is there any information in our record about this service issue in Tennessee?
No, the only thing in the record is that that the appellant indicated that he had attended a hearing and made pleadings in the state of Tennessee. So clearly there was engagement with the state of Tennessee in the pleadings as it relates on the magistrate's decision. So that part of the record is clear, is that there was participation there as far as whether service
was there a finding by the Tennessee court that there was service?
There was in the actual decision itself, which was attached to the magistrate's decision of Ohio. There was an indication that the court had found in Tennessee that service was perfected. And because service was perfected, any deficiencies would have been raised in Tennessee, as well as any other challenges to the jurisdiction would have been brought through the Tennessee appellate courts, as opposed to the Ohio courts. The magistrate acted in conformance with the UCCJEA by deferring to the first initiated action consistent with 3127.20 subsection B that conferred with the Tennessee court. Tennessee proceeded. This court, Ohio courts, were ordered under the 3127.20B to dismiss the case, which it did. And so jurisdiction, the way Ohio was correct in declining jurisdiction given the facts of this particular case, given that Tennessee had preceded and was first in right as it related to the filing of the initial case. It wasn't until January, more than 2 months later, did a case in Ohio initiate after the initiation of the Tennessee court, which would then make sense that there was that it was a case started here in Ohio after the appellant was notified of the action and appeared at in a February hearing in Tennessee. Because the trial court did not err, this court should affirm the decision of the trial court, and any further proceedings related to this particular child should be in the state of Tennessee, as that is a court that exercised its jurisdiction in this under the full faith and credit clause of the Constitution.
Counsel, wasn't the Tennessee final order entered by default?
It was entered by default.
But there was an appearance by appellant prior to that?
Yes. And there was an indication that there was pleadings filed, and the appellant had indicated that he felt like his pleadings were not heard, but he had appeared at a phone conference and made an initial appearance via pleadings in the Tennessee court based on the record that's before this court. Thank you, and if there's no further questions, I'll rest. Thank you.
Thank you very much. And Mr. Timmon, you have 1 minute.
So I I did not appear via phone conference in the state of Tennessee. I was defaulted. There was no notice of hearing provided by the state of Tennessee. There was a special appearance to challenge the jurisdiction personally and subject matter jurisdiction that was not regarded. The findings of facts by the magistrate actually display and admit to unjustifiable conduct, along with Tennessee not being the home state.
But if Tennessee found that there was jurisdiction and found that you were served properly, what are we supposed to do with that?
Well, I would say that they might have found something, but in regards to the appellee's admission that her filing was not pursuant to home state standards, that finding would make the pleading void, and it would make Ohio the home state.
Where did she admit that?
In the trial court. In the trial court.
In this case?
Yes, that's correct. In this case, yes. Sorry. Ohio does not make orders void; they are already void in and of themselves, and it's an inherent authority by Ohio courts to void orders. Sorry, to cancel out void orders, whether collaterally or directly vacating them. Yeah, there was a special appearance. I don't have much else to say other than that. And yeah.
All right. Well, thank you for your argument. Thank you both today for your arguments. Case will be submitted, and we'll get out a timely written decision.
Thank you.
Have a great day. Okay, the next case is In Re OGH. Morning, counsel. Mr. Moskowitz, you may proceed. Would you like to reserve any time for rebuttal?
Yes, Your Honor. Let me reserve 5 minutes, please.
Very well. You may proceed.
Thank you. Good morning. There's been a reply brief. I don't want to regurgitate everything in those briefs because it was a lot. So I'm going to start by asking right off the bat if you have questions of me, or do you want to wait until I start?
I would just go ahead and start, and
Okay.
our questions will come up organically, probably.
So, Your Honors, we have 4 assignments of error, and the first one is, I think, for our purposes today, probably the most important of it, which is the fact that the trial court adopted a proposed shared parenting plan, and then upon its adoption, immediately ordered modification to the terms of the plan. This, quite frankly, is not allowed pursuant to 310904 D1A3. So that section is very clear. If the court has an issue with any term of a shared parenting plan, they let the parties know what that issue is, and ask the parties to resubmit a plan that addresses the court's concerns. The case law is also clear. The trial court does not have authority to take a proposed shared parenting plan and then go through it, striking the provisions it doesn't like, rewriting other provisions, and make no mistake.
Well, and I understand all that, and I understand the case law on that, but if this was done essentially to make accommodations to benefit your client, like, is there a kind of harmless error analysis to be done there?
Well, there were no accommodations to benefit my client because my client opposes shared parenting. So these did not accommodate anything. And
right, but
presumably-
if she loses that battle and there's going to be shared parenting and she wasn't happy with certain terms of the proposal, and the court seemed to accommodate some of those concerns by the modifications, that's what I'm talking about.
Well, with respect, Your Honor, I mean, the law is the law. The court does not get to make accommodations violating the law because it makes someone feel good. And just because it might have benefited my client in some backwards way does not excuse the violation of the law.
Counsel, was this perhaps invited error on the part of your client by requesting, for example, change in the definition of sports activities?
My client didn't request a change to the definition. My client, what the objection was, I mean, some of the things that we pointed out in the plan was that sports activities was limited to like 3 or 4 things. We did not ask the court to change anything. What we did, what I do as a practitioner, when there is a shared parenting plan filed, I look for all the things wrong with the plan. I look for all the reasons why the plan can't be adopted. First and foremost, by the way, the plan itself says it was submitted under the code section where 2 people are jointly submitting a plan. That in and of itself makes you have to reject the plan in totality. You have to say, this plan is not in the best interest of the child. Here's the problem with the plan. You may submit something to correct it. The court didn't even do that. The court actually adopted a shared parenting plan that said my client jointly submitted it over my client's objection.
Counsel, aren't there separate inquiries here, beginning with first whether shared parenting as a concept is in the best interest of the child, and then looking to whether the specific proposed plan accommodates the child's needs?
Of course. Well, that was the other major debacle in this case, is the court's finding that the evidence supported a finding that shared parenting is in the best interest of the child, when in reality, the evidence, the overwhelming evidence at trial suggested exactly the opposite. I mean, there is a litany of stuff starting from the day my client learned she was pregnant till not the day of birth, months, even a year after the birth, that shows these 2 people could not agree on anything.
Well, but I think that the trial court saw it differently and saw that there were miscommunications based on styles of parenting and styles of interacting between the couple. And,
Sure.
And so, I mean, we have to defer to the trial court's evidentiary assessment. So how would you respond to that?
So we had a magistrate who saw the witnesses, heard the case, made a decision saying no shared parenting. We had a judge who came in, and I'm going to address what you said. What she did, and this is another one of my objections, is the judge sandbagged us and said, we're going to hear additional evidence. And she was the only one that was going to ask questions. And then she didn't hear additional evidence. What she did is she went back and gave Dad the opportunity to change his testimony, the very testimony upon which the magistrate relied in making some of these findings, and then said to Dad, okay, there's a lot of evidence here that basically you lied to Mom about quarantining, because specifically he texted the mother in the height of the pandemic and said, hey, me, my sister, my mother, we've all taken off of work and we're quarantining so we can see the baby. Only to find out days later that wasn't true. He was at work. He was exposed to someone at work. He wasn't quarantining at all. The magistrate used that as one of his findings. And by the way, Father admitted that that was a lie, that that was not truthful, and that he understood how that could negatively impact his relationship with Mom. The judge then says to Father, well, what did you mean when you said quarantine? Did you really mean that you weren't going to be there around anyone? Now, this is with the hindsight of knowing what the magistrate found, that the ruling had already been made against him. So, Dad, what does he say? Oh, no, no, of course. Quarantine would never mean that I was isolated from people. Because why would the normal meaning of the word apply? Why would a judge ask a party why a normal, everyday word would have a different meaning? It makes no sense. And yet she did.
And so that proceeding was by Zoom, correct?
Yes.
And were either parties put under oath and sworn prior to the questioning by the judge?
I didn't raise it, so I believe the answer to that was yes. It's been a while since I've looked at the transcript. Okay. But I believe at the beginning the answer was yes. I'm not, as I sit here, 100% positive of that.
Counsel, was your client given an opportunity to present any additional evidence at the objection hearing?
No. Nobody was given the opportunity to present evidence. The judge asked questions. So we were not given prior notice that the court would be doing this. As a matter of fact, in my brief, I pointed out the notice to us specifically did not mention additional evidence. It talked about reviewing transcripts, it talked about some other things, did not mention additional evidence. So under normal circumstances, you are given notice. You should be given notice. Additional evidence on this subject will be taken, so we have a chance to prepare and present. That's not what happened here at all. The judge just led into it. She asked these questions. I assert this was not additional evidence. This was actually a restatement of previously provided evidence. Now, there is a portion that the judge asked about that is new. She wanted to know things that had happened since last hearing. That would be additional evidence. But going back and allowing someone to change their testimony is not additional evidence. And kind of circling back to this first thing, it doesn't matter the circumstances. The statute is clear, the case law is clear, the court can accept your plan or reject it and ask you to make changes to bring to it to see if it complies with its objections. The court did neither here. It accepted a plan and then immediately modified it and modified substantive terms about how they communicate, about how to select, whether or not you need to select a new pediatrician, what the definition is of sports activity, and how the religion the child's going to be raised. Completely rewrote the provision that was submitted.
Do we have any reason to believe that Dad would not agree to these provisions? I mean, did Dad object when this new plan was offered?
These are Dad's, the plan is Dad's. Father is the only one who submitted a shared parenting plan. So
Let me ask you, Mr. Moskowitz, just assume we would, as you say, follow the law and reverse this and send it back to the trial court. It's my understanding that the father has filed a shared parenting plan that reflects the modifications the judge made, and what's to prevent the judge from just accepting that plan. And apparently the appeal was filed, and then the modified shared parenting plan, which contains the judge's changes, is waiting there, waiting for this case to come back so she can approve it. Right?
Well, my expectation is exactly that. My expectation is this court is not going to go beyond the initial question of, did the court err in adopting the shared parenting plan? My hope is that you would, and you would actually address all my other stuff and tell the judge below, don't do this because it's not right, but that's not my expectation. So I think exactly what you said. The minute this order came out, it was actually a discussion that I had with counsel. I believe we're going to ping pong. We're going to be here. It's going to go back. The judge is going to fix it to comply with your ruling. We'll be back here probably talking about the substance of the plan itself. But unfortunately, I don't think we get to the substance because the adoption of the plan itself violated the law. But if you should get to that, that would be wonderful. As my brief has pointed out, and my arguments that have been made pointed out, another thing the plan did was it included a couple provisions regarding expense division. Well, as I pointed out, the juvenile court in Hamilton County, Ohio bifurcates custody and visitation from child support. Literally, it is a whole different case number in front of a different magistrate. There was actually a child support case pending while this custody case was going on. No evidence had ever been presented in the trial court that decided custody of the parties' incomes or expenses. Nothing about their assets, nothing about their liabilities, nothing about the costs of the things about which the plan provided. No evidence at all. And yet,
Mr. Moskowitz, you're past your time if you still want to reserve 5.
nope, Your Honor. I think my brief says it all.
Okay, great. Thank you. Ms. Stagnero?
Good morning, Your Honors.
Morning.
I guess I could start with that last piece that Mr. Moskos was talking about with respect to the expenses. I see the sharing of the expenses that are listed in the proposed shared parenting plan is not necessarily part of the overall support calculation, which could be addressed under that paternity case number that at that time was pending. And the reason I say that is when we're determining child support, we're looking at the parties' gross incomes, we're looking at child care expenses, and we're looking at health care expenses only to determine the amount of child support to be exchanged, if any. The other factors, the other in-kind expenses or extraordinary expenses are a deviation factor the court can or doesn't necessarily have to consider. So it's not part of the support calculation. And I think having that in the shared parenting plan, the division of those expenses, would help the court in making its support determination. What we do have in the evidence before the court was we had 2 professional people that were gainfully employed. Yes, we don't know their exact income amounts, but if they had a shared parenting plan, they had equal parenting time under the terms of that plan, and they had equal responsibility for that child, and the expenses had to be agreed upon, it would not be an abuse of discretion, in my opinion, for the court to say, okay, well, then you're going to equally share those agreed upon expenses. We'll deal with how that affects support under that paternity case number, and that's exactly what the plan did. And the court certainly has the discretion to do it. I think they have the authority and the directive to do it under 3109A2 that says you have to include all provisions for the care and support of a child in a shared parenting plan. That is part of the requirements that the statute directs, that we have to do that in our shared parenting plans. So that's with respect to that particular issue.
Could you circle back to the first assignment of error and the failure to, or the court's modification of the plan?
And I understand. The court did say that it found that the shared parenting plan was in the best interest of the child. The issue was that there were certain things that I think, as you pointed out, Your Honor, that the court was making some concessions for mom, who raised those as concerns and addressed those concerns in its modification. But overall, finding that shared parenting was in the best interest of the child, when we're looking at all the statutory factors under F2, do they have the ability to communicate and make joint decisions together? Do they have the ability to share love and affection for the child for the other parent? Was geographic proximity an issue? The court found all those to be in the best interest of the child in saying that this shared parenting plan is in the best interest of the child. We're talking about the little nuances in the plan itself that the court said, well, mom had some issues with these, let's go ahead and incorporate those into the plan. Do I think the best thing for the court to have done is to say, Dad, make your modifications and resubmit the plan to me for a final approval? Yes, I do. But as you also said, Your Honor, I think this is kind of a harmless error situation. Within less than 2 weeks of the decision, we had filed a new amended plan that addressed the court's modifications. That could have addressed this issue, again, within less than 2 weeks. However, this appeal was filed, so the court lost its jurisdiction to be able to do that. And here we are a year later, still waiting for this to be finally resolved when it could have been easily resolved within 2 weeks. I think this goes more to mom has been very resistant to this since the very beginning for shared parenting, does not believe that the court made the appropriate decision on shared parenting, and again, we're here. But I do think that this court can do a limited remand to the trial court to say, go ahead and accept and adopt the plan that's already before you that has all of your modifications to resolve the matter.
Counsel, is there anything in the record that would allow us to imply that your client consented to the modifications?
I would say us filing the amended plan is one. The other one is we did not file our own appeal. We could have filed a cross appeal on those issues. We chose not to because my client accepted and adopted those modifications.
Did he object on the record at any point to these modifications?
No. I think these questions were asked of mom during the colloquy between the judge and the parties, and there was no objection from my client as to these particular matters.
Let me ask you, Ms. Stagnero, I did very limited domestic relations work, and there's a reason for that. But my recollection was that when you, or one would submit a shared parenting plan, there was somebody in the judge's chambers, or there was some person there, and I'm referring to domestic relations, I know this is juvenile court, that would go down the plan and make sure everything was copacetic or proper or included. Is that still the case, or is that was that never the case?
Actually, in juvenile court, it's a little different, where we have more of a compliance department in domestic relations court. We don't have that in juvenile court. It's up to the respective magistrate or judge to review the plan to make that finding. I guess kind of along those lines, I do want to point out, I know Mr. Moskowitz mentioned that the magistrate decided or made the decision that mother should have sole custody, that shared parenting wasn't in the child's best interest. That's not actual. That's not what happened. In fact, the magistrate made no mention of the F2 factors under 310904 at all. He didn't address whether they weren't in the child's best interest. He didn't say that shared parenting wasn't in the best interest. He simply chose to ignore those factors altogether in making his decision. And in fact, when he made his decision under the F1 factors, whether it was in the best interest, everything he found was in support of shared parenting. He found that both parents were appropriate parents. They had wonderful homes, and the child was well bonded to them and doing well and adjusted in each of their homes. They both had the ability to follow court orders. Everything he found was for shared parenting, but then he didn't look further onto the shared parenting factors to make that decision. And I think once the judge reviewed all the evidence, that she determined that shared parenting was in the best interest of this child, which was appropriate.
Can you address I think it's the third assignment of error about the Zoom hearing and taking, whether that was testimony, I don't know whether the witnesses were actually sworn. I don't know if you recall that or not.
With Mr. Moskowitz, I don't recall specifically. I would say almost 100% of the time, the court, before we do any type of argument, will swear the parties in, even if it is just an argument. So I have a feeling that did happen, but I can't be 100% certain.
I mean, because the notice was for oral argument, and so if I were a lawyer and got a notice that said oral argument, I would assume that meant it's argument, not testimony to be presented or evidence to be presented.
I think it's a little different than us being here today presenting oral argument.
Right.
When we're talking about an objection to a magistrate's decision, it's very different. And the reason is that once the magistrate makes a decision, that order is not a final order. It does not become a final order until the trial court accepts and adopts it or overturns it or whatever it's going to do. So it's not actually in place until it's finally ruled on. So that's one. So in between there, the juvenile rule, which is very similar to Civil Rule 53, but Juvenile Rule 44D, I think that's right, talks about there are different times or different abilities of parties to bring new evidence to the court between the time of the magistrate's decision and the objection hearing. And the reason is, sometimes that could be a matter of months. Something might have substantially changed that wasn't available. So under the D section of that rule, it says if there is newly discovered evidence that could not have been presented at the trial, a party has the ability to bring that before the court to have the judge rule on it. Now, the judge, it's discretionary. The judge can say, I don't want to hear it, or the judge can say, okay, I want to hear it, and then I'll, base my decision otherwise. And that's what Mother argued in her assignment of error. However, I don't think it's the D section that applies. Neither party came to the court to say, we want to present new evidence. That didn't happen, because I would agree that there should be some notice, some filing to say, I'm going to introduce this new evidence so the other party can be prepared for it. What we have is the trial court, after reviewing the transcript, the evidence, had questions. I mean, the trial court had clarifications that the judge wanted to hear from the parties, kind of explain to me what happened, or tell me what happened because of the wedding, because that was part of the magistrate's decision. Everything the judge asked related to the evidence that was presented at the trial or something that was inferential from that. It wasn't like the judge just out of the blue came up with something wild and asked the parties.
And the judge did ask the questions, and I didn't see any opportunity for cross-examination, but I can't recall anywhere in the transcript where someone requested the ability to cross-examine. Do you recall?
Yeah, that did not happen. This was more, and the way I took it was, as I was explaining, maybe I was being too long-winded, that the judge had questions about what was presented. As part of the court's job on objection is to make an independent de novo review of what was before the magistrate. Part of that is she may have had questions about things that were introduced. And I know Mr. Moskowitz and Mother have a very hard time with the issue that my client supposedly changed his testimony about what quarantine was. It sees that as a negative. It actually could have worked against my client just as easily. You know, if the judge is asking a question and the party says something different than they did at trial, that's going to call into question that party's credibility, and maybe I will make a different decision in my ruling. So it could have easily gone negative versus positive.
Counsel, let's assume that we adopt mom's perspective about the quarantining testimony, and that we assume that dad did misrepresent where he was and what he was doing with respect to quarantining. How does that change the shared parenting analysis, if at all?
In my opinion, it doesn't. What we have in this case is, we have to look at those statutory factors of whether shared parenting is in the best interest of the children or child. And what the court has to look at, there's two main factors, in my opinion, are the ability of the parties to communicate and to make joint decisions, and the ability of the parties to encourage love and affection between the parent and the child. One of the biggest issues that Mother had throughout this trial was that the parties don't communicate well. And I understand, her concern if she felt like Father was being somewhat deceptive initially during the relationship, but you have to look at not what may have happened before, but their ability moving forward to be able to share parent this child. We're talking about two people who basically had a one-night stand and had a child as a result of it. They really had no prior relationship. They had no idea who each other were as people. They didn't know how each other were as parents because this is the first child for both of them. They have both learned about each other, how to parent a child, in all of this in the middle of COVID pandemic. What the trial court saw and put in her decision was, I've seen a lot of growth with these parents. They may have made some mistakes. I think Mother made mistakes as well. For example, not putting Father on daycare for him. In fact, crossing out that there was even a father at all. There were things that they have done through the course of the case that, they could have done better, but they've done better. And the judge saw that ability for them to be able to do shared parenting and that being in the child's best interest. So that's why I believe that the court did not abuse its discretion in making that decision. Any other questions? Okay.
Thank you.
Thank you very much.
All right, Mr. Moskowitz, you have 5 minutes for rebuttal.
Thank you, Your Honor. To address what you initially asked me, I think the answer is no. I don't think anyone was ever sworn in at that time. I was just looking at the transcript and I couldn't find it. So, real quick, the fact that a trial is held, a magistrate makes a decision, objections are filed, you go to an objections hearing, and the judge issues a final appealable order is the end in the trial court. The fact that you then 2 weeks later, after an appeal is filed, go run and file an amended plan that corresponds with the changes the judge wanted to make does not change the deformities in the process. It doesn't excuse it. We don't say it's harmless error. It's not harmless error. What you are being asked to do is change the law of the land, not just the land of the first district. This is across Ohio. No court has a different interpretation, not one. And you are being asked to do something different than every other district in this state. To say, harmless error, under this scenario, the court can actually modify terms. But I want to jump to the fourth assignment error. I want to jump to the decision to grant shared parenting. And this is where I kind of ended when I was last up here. From the day that my client informed the father of the pregnancy, there's been disagreement. He asked her to get an abortion. They didn't agree on that. When she was pregnant, she asked him to go to prenatal classes. He wouldn't do that. He agreed to go to one parenting class with her, and uncontradicted testimony shows they were in there. He leaves because he's on a phone call for about half the time. Then she invites him to her prenatal appointments. He doesn't go to any of those. Then the baby's going to be born. They talk about quarantining so that he can actually come in and see the baby. He lies about that. He admits he lies about that. And there's one thing after another from that. They didn't agree. He lied and said that when Dad filed, he filed an affidavit that said, Mom only allowed me to see the child 4 times. And he admitted he lied. That wasn't true at all. The evidence showed that from day one, he had an open invitation. Anytime he wanted to come over, he could come over. The evidence also showed that contrary to his statements, he was invited.
Counsel, could I stop you
Yep.
there? I'm hearing some real inconsistency in your position.
In my
on the-
position?
Yes. On the one hand, I'm hearing that your client thinks that Dad is a horrible father, that he doesn't show up, he lies, he's not present. And then on the other hand, I'm hearing that there's this open invitation and he can come whenever he wants, which I hear as an effort to paint Mom as being very open. And so there's this inconsistency in what I'm hearing, that Dad is terrible, he shouldn't be around, he's not fulfilling his role. But yet Mom is, going to allow him to be present as often as he wants. Can you address that?
Yeah, that's simply not true. Nobody ever said that he's a horrible person. Nobody ever said that he shouldn't be around. That's completely not factual. He is the father. It's very important for the father to be involved. They disagree on how he should be involved. They disagree on how much he should be involved. What Mom was doing, if you actually read the transcript, Mom was breastfeeding the child. There was a schedule. Mom was trying to work Father in around that schedule. And the push and the pull, what you saw was Father didn't care about the schedule. Father didn't understand the schedule. Father didn't understand the child's needs. Father wanted his own needs met. Father wanted more time. It didn't matter what the child was doing, what the child's schedule was. That's the push and the pull. This man deserves to be in his daughter's life. That was never a question. So the idea that there's an inconsistency is simply not supported by the evidence. And also it falls into the trap. And here's the trap. That thought process tells people, even if you think that it's the best for the child to have the other parent involved, unless there's a court order already, don't do it because it's going to be used against you. Somehow opening your heart and your life to allowing the parent, who is important, to be in the child's life somehow is a strike against you for shared parenting because you're simply doing not only the right thing, but the logical thing to do. He is the father of this child. He deserves to see the child. That is something from the get-go my client understood, and it still holds true today. He is not a horrible person. He is not a horrible father. The horrible things are their relationship. He has created a foundation of mistrust through lies and misstatements, and honestly, flat out just ignoring the situation. And that's the problem. And then you have the age of the child who was still breastfeeding, still had a schedule. I mean, I don't know what everyone's situation is, but when you have newborns, even when they're up to 2 years old, schedules are tight. There's not a lot of time. They're feeding, they're sleeping, they're eating. That's kind of the process. He didn't care about any of that. He wanted his time. So what you see through the transcript at the beginning is the push and the pull is Mom saying, no, let's get you time around the child's schedule, and Father saying, no, I want time around my schedule.
And
That was-
Mr. Moskowitz, you're at your time now.
Thank you, Your Honor.
Thank you both for your arguments today. The case will be submitted, and we'll get out a timely written decision. Have a great day. Okay, the final case on the docket today is Danziger versus Morgan Verkamp. Mr. Sparks, you may come forward. Mr. Would you like to reserve any time for rebuttal?
Can I reserve 3 minutes, Your Honor?
Absolutely.
May it please the court. There's a lot of issues to cover here today, essentially every issue that was before the trial court. I'm going to refer during this argument to the appellees, the Morgan Verkamp parties as Morgan, just it's easier to speak that way, and of our client as Danziger. The trial court here dismissed Danziger and Driano's complaint as a matter of law, despite there being no controlling case law on critical legal issues raised in the case, and without the development of any facts necessary for those issues and other illegal issues in the case. And Danziger asked that this court reverse the trial court's dismissal and remand this action for development of the necessary factual record. And as the parties are arguing this morning, I'd ask the court to note that the lead cases that are cited by Morgan are all cases that have been decided after discovery was completed and some after trial. For example, their argument about intent of the parties on the written contract issue, the Vogel versus Albee case, that's a post-trial decision. On accrual of an implied contract.
What about, so on the written contract issue, under the Ohio rules, if you have a written contract and you're suing on it, you're supposed to attach it to the complaint. And I didn't see a written contract attached to the complaint. So, and I also, as reading the complaint, I see like noise, but I don't see like this is the written contract, these are the terms of the written contract.
Well, Your Honor, first, that argument was not raised below so that we could address it in front of the trial court. That was raised for the first time in the brief filed in this court. Our complaint does, and we have not here just one particular contract that we are able to put in the record. It is a series of writings that are together going to form the contract. We discuss every one of those. We reference those. Some of them are cited or are screenshotted in the complaint. So I do believe that we've covered what the various writings that would be the written contract.
But is there a writing where the client signs on to the allocation of fee sharing between the two firms?
There is not a writing that the client signed on for that particular issue, Your Honor.
Okay. And so does there need to be, under the governing rules of professional conduct, whether they be Texas or Ohio?
Your Honor, for purposes of this case, no, I don't believe that there needs to be. First off, the Pennsylvania rules apply in this case, as we've argued and we've argued in our brief, not the Ohio.
But neither lawyer is barred in Pennsylvania, are they? Or neither firm?
Neither firm is barred in Pennsylvania, Your Honor, but the case out of which this dispute arose occurred in Pennsylvania. And
right, but if you're an Ohio lawyer making a contract with a party, a client, even though that client wants you to sue in another jurisdiction, you're still bound by the Ohio rules of professional conduct.
Well, Your Honor, I guess you could be. But the dispute here between these parties arises from the fee that was determined in the Pennsylvania case. And as this court is aware, given all of the litigation that occurred between the parties, first in Pennsylvania and then in Texas, and a dispute as to which law would apply and where the case should proceed, we end up here in front of this court. But what the parties here, Morgan and Danziger, both had an agreement on the amount of the fees that would be divided, how they would be divided in this case. They had been doing it in cases already.
Counsel, wasn't that agreement, if we find it to exist, wasn't that agreement with Volkema Thomas and not Morgan Verkamp?
Your Honor, it certainly started at that point in time, but when Mr. Epp, as the court is aware, Mr. Epp went away a couple of times and came back. When he resurfaced the first time, he was told that by Mr. Morgan, who was then had his own firm, that he would handle the representation under the same terms.
But that's a communication between Mr. Morgan and Mr. Epp. That's not a communication between Mr. Morgan and the Danziger firm.
We were on that, Your Honor. That was at a point in time when we were still involved. So the first time he resurfaced, Danziger was still involved and was on those communications with Mr. Morgan. It was the second time when Mr. Epp came back where we were not included. So at that time, we were on that communication and that confirmation by Mr. Morgan that they would handle the case under the same terms.
And so that's the email that you allege forms the written contract.
That's one of them. You know, there are emails in April and May and June of 2007 that between both Mr. Epp and Mr. Morgan and Danziger that determined how the fees would be divided in the case, what they would be based on, that the lawyers were going to share the fee. And when Mr. Morgan moved to his own firm, he confirmed that we would still handle the arrangement under those same terms, were the words that he used. So it was also an agreement with Mr. Morgan at his new firm. And the agreement on the amount of the fee, Your Honor, Morgan acknowledges in its brief in this case that there was a course of dealing and that the parties would share the fee, a third, and a third, with the final third to be divided based on the amount of time put into the case.
So the course of dealing argument, is that the same as the emails or a separate argument on your part?
It's part of the parties' agreement, the written contract being represented by the series of emails and communications among all of the parties, as well as the Danziger and Diano's understanding with Mr. Morgan and his new firm of how the fees will be divided. Because at the very same time, Your Honor, that Mr. Epp resurfaced the second time, Danziger and Morgan were practicing False Claims Act cases, 3 other cases for 2 different plaintiffs at that very same time.
All right, so I want to be very clear about what precise contract your client claims to exist. The course of conduct with the other cases, your claim is that that course of conduct influences how we interpret the written contract?
Yes, Your Honor.
All right, thank you.
Well, but let me ask you this. So we've got the rules of professional conduct that say you can't have oral contracts for purposes of contingency fee agreements. And if we were to find that this was an oral contract, at least is how you've pled it, how can we enforce that consistent with the prohibition on oral contracts in the rules of professional conduct?
Your Honor, the King versus Housel case that was initially cited by Morgan in this case is an Ohio case. The Ohio Supreme Court was looking at the enforceability of an agreement between lawyers to work on a case together and share the fee. In that case, the court's point in that case in not refusing to enforce the agreement was that you cannot use the rules of professional conduct as a shield or as a procedural weapon when you are trying to do something that is against the law. In that case, the court did not say that any terms of those agreements were not enforceable because they were not enforceable under the rules of professional conduct. In fact, that is the only case that was cited to the trial court and even here today in this court that is the basis for that argument. So the rules of professional conduct, at least from the Ohio Supreme Court dating back to the mid-90s, have not been able to be used as a shield when you're trying to avoid improper conduct of your own.
Counsel, if this is an oral contract, how do we get around the statute of frauds?
Your Honor, again, that was not raised. The statute of frauds was not raised in this case. The issue in this case is, and we're left to question or guess what the trial court actually ruled upon in this case. We have no opinion. But the issue in this case was whether or not that was a statute of limitations. Did it start to run at the time of breach or when the misconduct was discovered? The statute of frauds was not an issue that was discussed in this case or briefed below or here. And on the oral contract, Your Honor, below and here as well, Danziger cited 7 cases from, I think, 3 appellate districts dating back to 1993 that reached the conclusion that the limitations period begins to run when you discover the breach.
So there's a split of authority, there's cases going both ways, and as I read those cases, there's not a whole lot of analysis as to should the discovery rule be adopted or not. So persuade us that the discovery rule is the rule that we should apply here.
Well, Your Honor, it's a fair point, and the cases are a bit confusing when you read them as to what rationale or rule they're applying. It's a accrual sometimes it's a discovery rule, there's others as well. But those cases, Your Honor, are clear and consistent on 2 points. Even the one cited by Morgan. The first point being you have to develop the facts first, because these are very factually dependent decisions and determinations that are made by the court. The second.
So should whether the discovery rule applies be a case-by-case basis? That's what I'm having trouble understanding.
Well, Your Honor, under those, in an application of the discovery rule, or however the rationale is that the court's applying it, again, it's not clear. The second point that is clear, that is consistent, is that under the right facts, that a cause of action is not barred when the plaintiff had no knowledge that the contract had been breached. And I would submit here that the facts in this case are the right facts, Your Honor. Because Danziger had no knowledge that they had breached the agreement. So I think, Your Honor, even in those cases where it is unclear or where the court rules that the discovery rule does not apply, it's ruling really that it does not apply under the facts of those cases. If you look at the decisions cited by Morgan, those are, and that is in fact the ruling. They don't say the discovery rule that it doesn't exist. They say under the facts of that case it doesn't. So I do believe that that has to be a determination that you make in the case.
Should there be a constructive knowledge component of the discovery rule? At least your opponent is arguing that here because the judgment in the case was in the public domain.
It became at some point after it came out of seal, Your Honor. But the constructive knowledge, there are cases that find constructive knowledge. But I'd submit to the court that in looking at those decisions, what is consistent among those decisions is that the plaintiff in those cases have actual possession of some facts. Like in the Palm Beach case that they cite, Your Honor, Palm Beach had evidence that it had statements about what it had been charged and what it had been paying for its services over the years. It just didn't understand it. Even if you don't understand it when you have possession of the facts, you can be charged with that constructive knowledge. The Greenwell versus Freed case is another example of that. Here we had no reason to believe that they were out representing Mr. Epp. We had no knowledge.
Counsel, didn't your client ask much earlier whether Morgan had taken Epp and filed a complaint behind their back? Wasn't there some evidence in the record of suspicion on your client's part?
Well, this was long before Mr. Epp. I think it was before he came back the first time, Your Honor. And there was some discussion about another case that had been filed, and I think my client said, thinking that he had gone somewhere else because Mr. Epp was trying to settle the case or resolve it himself, or maybe he was speaking to other lawyers, asked, is this the fellow that we had talked to? And they responded, no, it's a different case. So, so that didn't give us reason to believe that they might take Mr. Epp and represent him. And in fact, as I mentioned before, they were practicing cases together. They settled one in 2010, I believe. They settled another one in 2012, and they settled another one in 2016, all practicing them together under the same type of agreement that they had here.
So I'm sorry. Go ahead.
What do we do with the public policy concern that we might have in this case, given that your client is essentially seeking a very large referral fee that is barred by the Ohio Rules of Professional Conduct?
Well, Your Honor, I don't think it is barred by the Ohio Rules of Professional Conduct. The court never found that. The public policy issue here, Your Honor, is that that the lawyer should represent their client and prosecute cases in their best interest, which is what both of these firms were trying to do. That's what Danziger stood ready to do. And they made an agreement, brought a client to Morgan Verkamp and made an agreement with them as to how they were going to represent that individual. And then whatever happened at the end when Mr. Epp resurfaced, it's not that he is told, it's clear from the email that he is told he knows that Danziger is still out there. Mr. Morgan says, we can check with them and see if they're still interested. Of course they were interested. Of course they were interested and willing to represent him with them, at no additional cost to Mr. Epp, of course. And also saying to Mr. Epp, we will compensate Danziger for the time they have in the case. That's what he told him at the time. We heard nothing from them. We have no idea what Mr. Epp's response is. We have no idea if Mr. Epp rejected that. We know nothing about that after that point in time. The discovery that was done on the jurisdictional issues in the other two cases doesn't shed any light on that issue, Your Honor. So the policy here, I think the public policy should be that when a lawyer makes an agreement with another law firm to represent a client, and they're going to both prosecute cases together like they had been doing multiple times over many years, they should be held to that agreement.
And you're at your time if you'd like your rebuttal.
Thank you, Your Honor.
Thank you. Mr. Johnson?
Thank you, Your Honor. May it please the court? I want to briefly point out three issues that were not addressed, that were addressed in the motion to dismiss that were not addressed in this court. Number one, the fraudulent concealment claim that was made has a 4-year statute of limitations, and that's clearly gone. That wasn't opposed. Second, there were no facts supporting the claims against Jennifer Verkamp. That wasn't addressed in this court. And finally, and most importantly, fee disputes in Ohio can't be litigated. Fee disputes between lawyers of different firms have to be taken to fee mediation or arbitration under the Ohio Rules of Professional Conduct, Rule 1.5F.
Did you file a motion to compel arbitration?
No, but that was one of the bases for our motion to dismiss. It's upon them to initiate it. I don't think it's upon us to move to enforce it because there's no arbitration.
Well,
agreement.
typically, I mean, we see this not infrequently outside of the fee dispute context, but if a party has an arbitration agreement, they get sued, they kind of try to have their cake and eat it too, and so they oppose the motion to dismiss, or they file a motion to dismiss, and then at the end they're like, oh yeah, give us arbitration as an alternative. But I feel like you need to pick one or the other, and either this dispute should be in arbitration or it should be in litigation, filing a motion to dismiss.
Right, and I agree that 100% of the time when there's an arbitration agreement that the parties have agreed to, that you can choose to waive that or not because it's an agreement. This is the law in Ohio. You can't litigate these claims. You have to arbitrate them, and it's incumbent upon them to bring it in the right place. And so a motion to dismiss, respectfully on our part, was the correct way to address that failure.
Is that a jurisdictional question?
It is. And that section of the Ohio Rules of Professional Conduct has been found to be constitutional by the Ohio Supreme Court. So getting into the facts that you all have been discussing, first of all, there was there was an action for discovery in Pennsylvania State Court, and factual discovery was done, not just jurisdictional discovery. Jurisdictional discovery was done in Texas. The plaintiff tried to initiate this case in Pennsylvania for the very reason that Pennsylvania professional conduct rules allow a pure referral fee, a naked referral fee. I can get a referral fee for introducing a client to a lawyer at a cocktail party in Pennsylvania. That's not true in Texas, and it's certainly not true in Ohio. We got the case dismissed in Pennsylvania, and the Third Circuit Court of Appeals, in its opinion, which is cited, talked about just how different what's at issue here is from what happened in Pennsylvania. The quote from their brief is, "Here, none of Danziger's 6 contract or intentional tort claims arise out of or relates to Morgan Verkamp's activities in Pennsylvania. At bottom, it claims alleged that Morgan Verkamp refused to pay Danziger the promised referral fee." So the Ohio Rules of Professional Conduct say the rules of another jurisdiction can apply if the conduct at issue happened in a matter in front of a tribunal in that other jurisdiction. The Third Circuit said not only did the claims here not arise out of the actions in front of the Pennsylvania court in the underlying matter, but they didn't relate to any of Morgan Verkamp's activities in Pennsylvania. So Pennsylvania rules clearly don't apply. And then we get into the kind of a flow chart. Well, do Texas rules apply? Texas rules certainly apply to the conduct of Danziger, but the Texas rules have similar requirements to Ohio. And the Texas rules, the Texas civil law says distinctly, if the contract violates the rules of professional conduct, it's not enforceable civilly. We have binding case law from Texas in our brief. They haven't addressed that. So you can't bring the claim in Texas under the Texas professional conduct rules. So we're in Ohio. We don't have a written fee, contingency fee contract, which is the first thing. And then we're going to share fees from lawyers in two different firms. The division either has to be in proportion to the services rendered, or both lawyers have to be jointly responsible, and both lawyers have to agree to be available to consult with the client, and the client has to be aware of the identity of both lawyers and has to consent in writing. We have none of those things. What we have here is a claim for a written contract, and alternatively an oral contract, that allegedly occurred between Volcom and Thomas in 2007.
Can you address, let's assume for a moment that it's an oral contract. Right. Can you address the point I was debating about the discovery rule and how that applies in terms of the split in Ohio authority on this, and whether it is a case-by-case analysis or whether it is as a matter of law, and what your best support is for that?
The existence of a discovery rule or not, I mean, whether a discovery rule applies to a certain case is certainly based on the facts of the case. Whether a discovery rule exists has to be a question of law. Mm-hmm. It either exists or it doesn't. And this very court in Dunn versus Bradstreet said something that was very instructive with regard to a claim that a discovery rule should be created in an unjust enrichment claim. And that occurs on page 5 of the decision there. Although Palm Beach invites us to create a discovery rule for unjust enrichment claims analogous to that for fraud claims, the discussion in REIT 1 versus Jacobs, an Ohio Supreme Court case, concerning the appropriateness of implying such a rule in the absence of legislative action counsels against accepting such an invitation. So what you have said in the past is, we're not going to create that kind of a discovery rule, a different accrual rule, unless we get a heads up from the legislation. And what has the legislation done with regard to oral contracts in Ohio? A year and a half ago, they reduced the statute of limitations from 6 years to 4 years. So we know which way the legislature is heading in terms of statute of limitations, and it is not towards lengthening them. The written contract, and maybe we don't need to address it much, but again, the contract that was drafted and sent to the client said it had blanks for the percentages between the division of fees for the two firms. And Morgan called that out to the client. He said our relationship with Danziger has not been solidified, and when it is, you'll have to consent to it. There is no writing at all that solidifies any kind of a fee split. The oral contract that they claim was allegedly made before that draft contract was sent in 2007. The complaint alleges that the oral contract was made in May, and this oral contract was sent, the written contract was sent after that, and the blanks were not filled in. They were never filled in.
Counsel, can you address the statute of frauds as to the oral contract?
It's an intriguing question, and the truth is that Danziger, the statute of frauds requires that a contract for the provision of services for more than a year, over a period of more than a year, be in writing. And nobody expected Danziger to perform any services. What Danziger had done in these previous cases was find a client from its well-funded website, hook up Volcom and Thomas, Morgan's previous firm, and then with the exception of work that it did in the state court case in Texas that was related to one of those previous cases, it was not a player in the federal QI-TAM cases. So they weren't expecting. Danziger wanted to make a referral fee, and that's the reason why the contract percentages were never filled in. That happened in 2007. The client actually came back in 2010 And it was in 2010, in January, when Danziger called Morgan and said, or wrote to Morgan and said, hey, I see a case, is this up? And Morgan said no. About a month later, it resurfaces. So there was a draft contract that was never formalized, never finalized in 2007, a contract that was signed in 2010 that didn't include Danziger. So the various causes of action, the oral contract should be an accrual date, and certainly the constructive knowledge issue is an alternative trigger.
And you mentioned Texas authority that said if it violates rules of professional conduct, it's unenforceable. Is there similar authority in Ohio that would say if your oral contract violates or your contract violates rules of professional conduct, it is not enforceable?
There isn't a case that says that, but King versus Housel is extremely instructive on that point. The court in King versus Housel was faced with a case where there was an actual contract. The client knew about the contract between the two lawyers. The other lawyer actually participated, but the client allegedly knew only about the hourly part and not about the contingent part. So client knows that the second lawyer is involved, second lawyer actually participates, client knows the second lawyer participates, and the second lawyer says, well, there was a second component to our oral fee agreement, and the first lawyer says you can't raise that because it's not in writing. And the Supreme Court in Housel talked about estoppel, and they said we're not going to let a lawyer make a deal and then hide behind the rules. But they said very clearly there that their ruling was based on the existence of a valid contract. And they cited, and this is the previous set of professional conduct rules in Ohio, one of the purposes of DR 2107 is prohibiting the sharing of fees where there is a lack of services performed or responsibility to the client. That's what it's all about. You can't do a naked referral fee in Ohio. The court goes on to say the service and responsibility referred to in the rule relate to an actual participation in or work on the case. Danziger doesn't even claim that he did actual work or participate in the case. He didn't do any work. He didn't share joint responsibility. He didn't agree to consult with the client. The client wasn't aware that he was involved after 2010 when the binding agreement was actually signed. So, and I invite you to base your opinion on that rule of professional conduct, because that is how the case should be decided. It should be decided on Rule 105 that requires a written agreement that lays out the things that the rule requires. It should be based on the fact that a contingency fee agreement in Ohio has to be in writing. And it should be based upon the fact that fee disputes can't be litigated in Ohio. If you don't have any other questions, I appreciate your time. Thank you.
Thank you. All right, Mr. Sparks, you have 3 minutes left.
Thank you, Your Honor. Your Honor, on continuing the discussion of King versus Housel.
You both think it supports you.
We do.
What a great case.
We do, Your Honor. And for the reason that King, like this case, involved an oral contract that was not signed by the client. The court did not strike down that agreement based on the Ohio Rules of Professional Conduct. Also notably, on another question from the court in an argument from Morgan, it also didn't order mandatory arbitration. And mandatory arbitration, or whatever that is in the rules, was a thing back then under the old disciplinary rules. That's confirmed in the comments to the current Rule 1.5. So King was an oral agreement between two lawyers for the representation of an individual in a personal injury case that was not signed by the client.
Counsel, what about the fact, though, in King that the client knew and had a relationship with the other lawyer?
Well, here, Your Honor, Mr. Epp did too. Mr. Epp had his initial relationship with these two law firms was with Danziger. And he continued to reach out to them even when he resurfaced in 2008 the first time.
Is that in the complaint?
Yeah, that's at the time, yes, because we were having the 2008 communications are with all three parties at that time.
And that's in the complaint?
Yes, Your Honor. So why he reached out to Mr. Morgan alone, apparently, or how he got in contact with Mr. Morgan, we don't know because we have no facts. And again, in King, that's a summary judgment case. And the court looked at it concluded there was a valid contract because it had conducted discovery. There was discovery that could show whether there was a valid oral contract or whether the terms of various writings can constitute a contract. That could also be shown during discovery, which was completely prohibited here, without any development of any facts by the trial court.
Well, but I'm having trouble understanding why you need discovery to figure out whether there's a contract. Like, you are, by your own position, a party to this contract, so you should know what the terms are and what the basis for it is. Like, why do you need discovery of the other side to confirm whether there's a contract or not?
Well, I think that there are the unanswered questions, like where, and this was never been answered in any of the discovery in the other cases, whether it's jurisdictional discovery or otherwise, is how did Mr. Epp come back? Did Mr. Epp contact Mr. Morgan? Did Mr. Morgan contact Mr. Epp?
But why is that relevant from a contractual existence standpoint?
Well, because I think, Your Honor, that in terms of looking at all of the facts that the cases have analyzed and the cases that have been cited to the court, what the court does is essentially distill those facts down and determine whether or not they establish both either the written contract or what the terms of the oral agreement are. Now, we have alleged that there is an oral agreement, and to the extent, Your Honor, that there is any evidence in the record, it is our evidence that there is an oral agreement. So it's the defendant's arguments, for example, that the party's intent was to reduce the agreement to a formal written contract. But that intent, of course, was never the subject of any discovery in this court. So I would prefer that we accepted our allegations that there was an oral contract or that these writings represented a written. But we don't know what the court did.
Okay, you are at your time.
Thank you, Your Honor.
Yeah. Thank you both for your arguments today. We appreciate them. The case will be submitted and we'll get out a timely written decision. Hope you both have a great day.